Good evening, viewers. We're talking about public liability, and in particular, Tony, the case of Hawkesbury.
Yeah, we're just discussing the issues of Mrs. I can't remember her name.
Angel.
Angel. She was an angel, wasn't she? The court loved her.
That's right.
She succeeded, not so why.
Basically, the court determined that in this case that the displacement obviously was a causative of her injuries, and that it wasn't an obvious risk, and that
Do you know what wasn't obvious, John? Do you know what wasn't obvious? I'll tell you why. There was tree branches overhanging, yes. And at that time of day, they were creating shadows right over the spot where she tripped. Exactly. Now, interestingly, someone went back and took photos. What, about an hour and a half later?
Her son. About an hour and a half later, yeah.
And the shadows moved. Ooh. And so there was a lot of debate and contention in court.
And what about the issue of the council officer?
Yeah, there was another thing. A council officer had inspected, and they said that she wasn't an officer within the meaning of the Act, but the court found that...
Yeah, but our background to that was that when the plaintiff called the council to notify them of her injury, the council representative mentioned that an early incident had occurred and they were aware of I suppose, the displacement.
They were aware of it and that they were going to do something about it.
Yeah, so that actual knowledge.
But was that denied at the hearing?
They say that because she wasn't a senior, council representative, that it's not, hasn't fallen on the council.
Fortunately, the court saw through that, didn't it?
Can I just say this? She was almost like a perfect witness reading this judgment. She said she looked on the ground. Right. She was looking within 2 feet of where the raised concrete was. She says that there was tree branches overhanging. There was shadows. It was almost like it was a perfect story.
Also, she also had 2 witnesses who were there at the time who also confirmed the fact that the trees were overlooking the footpath and created the shadow effect.
Because the law in this area is pretty tough, isn't it? What did the court in Brodie say, John? That you can't sue for obvious?
Well, you need to have an obvious risk, Tony.
No, if there's an obvious risk, you can't sue.
It's a complete defence.
So in this case, what the council was saying was that the raised portion of concrete was obvious.
That was
to the normal
defense.
person,
that was their
keeping
defense.
a proper lookout.
Exactly right.
She also gave evidence to say that when she walks, she actually looks at the ground. And she says that she was looking even within 2 feet of where she fell. I just thought she was a perfect witness. I mean, this lady was really, really switched on. Well, everything sort of fell into place for her.
Nuncio, you've done a lot of these cases over the years. They're very tough, aren't they?
Look, council cases are becoming more and more difficult because obviously there's a lot of statutory defences and also statutory protection and also common law defences in their favour. And with the Road Management Act, councils are protected a lot more. And look, it's becoming difficult, John.
So simply slipping on the footpath,
you're not going to get
you're not going to get compensation.
No, as I said, unless you've got some sort of knowledge or actual knowledge on behalf of the council.
Now,
it's
what
difficult.
about the situation where a judge has stated that you're walking along and something occurs which is akin to a trap?
Well, that...
if there's works in the area, they're the best cases because they haven't probably barricaded.
Then you've got more parties who can be involved. You've got the builders, constructors, and
subcontractors,
and you prefer them in your proceeding because they don't have the defences available to the council.
No, let's just keep moving. What did she get in this case?
She got $162,000.
And what was that for?
And purely for sort of home help. The fact that
domestic services.
Domestic services. As well as her injuries, she can't do the things that she used to do at home. And the court,
cleaning, cooking, vacuuming, this, that, and whatever.
And the court found in her favour. And that's a big settlement, a big judgment.
And under the Wrongs Act in Victoria, we need to have 6 hours a week for 6 months.
That's the test.
To be able to claim that.
To qualify for domestic service, that's the test.
And you can't claim that under the Accident Compact or Transport Accident Act.
Not at all. That's precluded.
So it's a big, big benefit, isn't it?
Oh, it just brings to light that in cases such as this, if you've got your sons, daughters, and husbands and wives helping you out, you should document what they're doing and the time they're doing that for you because I
think the doctor, you've got to have a doctor to actually say that in their notes that you've actually got someone doing the work for you.
And
exactly.
A particular note, Tony, also with domestic assistance claims, you don't need that 5% we were referring to before.
No.
I said that is really just come down to evidence and your injuries.
And you don't need the 5% for medical and like expenses either.
Exactly right. Or loss of
Nuncio, what about the 10% threshold for psychological claims?
Yeah, on physical injuries, you've got 5% under the AMA guides. For psychological claims, it's 10%, which is even harder.
The other thing that's important in these claims is that you've only got 3 years to sue or date of discoverability. What's that mean?
Well, basically, 3 years can obviously from the date of the injury, but the day discoverability, sometimes you're not aware that you actually got a claim available to you for your injury.
You don't know that you can sue anyone.
No, a lot of people don't. You know, you might fall and think, oh, look, I'm fine, and there's no compensable injury.
You don't realise that you're actually suffering from the injury until later years down the track.
Or I think what the
or as a cause of the negligence.
You don't realise that you can sue someone, John. That's more to the point, I think. Yeah. I think they're more concerned about whether you know that you can sue someone, that you got rights.
Well, you've got rights, but also you might actually not realise the problem, Tony, until about 2 or 3 or 4 years down the track, and then you realise, oh, you know what? I actually do suffer from that particular injury that occurred 5 years ago. Well, then you can sue, can't you? Then
I think that's harder.
I think that's harder. Look, it is difficult, and look, the defendants will probably take the point on that. But you know, you can extend that limitation period, and it's still available.
There's a long stop, short stop. There's up to 12 years. That's a long stop period. But you can get extensions. Depends on circumstances.
Exactly right.
Can we go to another case? No. Can we go to the case of Raciti? Yeah, tell us a bit about Raciti.
Raciti is a case in which a plaintiff, or the person in this case, was walking down a set of stairs. There was a ramp that was, I suppose, extending from the ground to the 4th step. As she approached that 4th step, she moved to her left to walk down the remaining stairs, and obviously that reduced the width of the steps. As a result, missed a step and fell. And obviously suffered some major injuries and made a claim.
John, she lost?
She lost.
You don't get compensation for just missing a step, do you?
Well, in this case, John, she argues that the ramp created the risk, and that's why she fell.
Okay. She's trying to say that because of the ramp and the difference in heights, and in fact it gets worse than that, the actual steps weren't in compliance with the building regs.
Exactly right, but that wasn't.
But that's not what caused the fall.
That wasn't the cause of the fall. Her alleged cause of the fall.
Oh. She fell because the court said that what caused the fall wasn't the ramp.
All right, so you can have a situation, Tony, where the steps and the staircase is defective or simply unsafe. And you need an expert engineer at court to back you up on that.
Oh, there was experts here, but she still lost because the actual ramp wasn't the causative reason why she fell.
Exactly. Right. So look, I find that strange, Tony.
I reckon she's unlucky, personally.
Because the reason why she moved from a right to a left was because of the ramp. And
could you imagine, once you find that... Do you remember that guy that fell out of the balcony, the lacrosse captain? And there was, 2 inches shorter than what it should have been, and the judge in the Supreme Court found that there was a statutory breach of the regulations.
Well, Tony, you know, last year I got a lady $250,000 for pain and suffering for falling down a flight of stairs. That was a damages trial. A jury came back and said those stairs were unsafe, Tony.
Yeah, well, there you go. I mean, if they're in breach of the regulations and building codes, you'd think you've got a pretty good claim. So I think she was a bit unlucky. Look, people, I think you should get advice from a lawyer when you're dealing with these sorts of cases. They're very complex areas of law. There's the test to get over, 5%, 10%, liability, causation, breach. All these things are very, very difficult. I think it's important that you get advice early because evidence seems to disappear. So, it's an interesting area of law. We'll have to do it another time because it's very, very complicated. Nuncio, thanks for coming on board. I understand you're staying for the questions.
I'll stay for the mailbag.
John, you're having a bit of a break, are you?
I'm conceding to the expert, Nuncio, in regards to public liability, Tony.
Okay, viewers, stay tuned because we're going to a sponsors break and we're back with Kathy's mailbag. Thank you.